as the matter of the gravity of the alleged crimes
analyzed
and
the
concomitant
material
sentence
in
against
case of
this
conviction.
standard. According to the appeals chamber observes that the defense
accordingly,
does not
the defense
explain
has failed
why
to demonstrate
that the pretrial
view
chamber
these
misapprehended
factors
the
were
legal standards relevant
to the pretrial
to
chamber's
the assessment of risks under
Without more,
Article 58.
the defense has failed
to
of the
substantiate that the pretrial chamber's reasoning and
With
assessment
regard
to the
were
pretrial chamber's
unreasonable.
assessment and weighing of evidence in assessing risks pursuant Article 58(1)b, subparagraph 2 of the statute.
In the same vein,
the appeals chamber
defense
notes
fails to
that
demonstrate
that the pretrial
made
chamber's
reference to
reliance
5
on Mr.
documents,
Duterte's re-election as mayor
including
of Davao City
media articles,
in its assessment
publications
of the risks
of
under
non-governmental
Article 58(1)b
and
and
a book
paragraph 3
which,
of the
in its
statute
view,
was
indicated
that Mr. Duterte's motivation to interfere with
with regard to the
against
defense's
contention that the pretrial chamber
in
relation to the first
cited
document
facts
and
a
ignored
media
others
article,
in the same
the appeals
items
chamber
of evidence that it was not
the appeals
unreasonable
chamber considers
for the pretrial chamber
that the defense
to
has
rely
failed
on
to
demonstrate
this document for
how
its
the
finding.
fact that the pretrial chamber accorded
Whilst
weight
this
to the
document
statement
does
from
not
Mr.
mention
Duterte,
Mr.
that
Duterte
it cited
himself as
should
being
result
directly
in the
involved
pretrial chambers
in
in
briefing
briefing
individuals
or attaching
it
in
does
no
not
way
refer
other
to statements of
close. It does refer
regarding
to
gravity
statements of close
and
concomitant
associated
sentences,
including
in case of
one
conviction,
where individuals
would have been
It is
told to
recalled
remain
that the
loyal.
appeals chamber has consistently held
In any event,
that these factors
the appeals
are relevant
chamber
considerations that
Mr.
in assessing the risk
alleged
under
involvement
Article
in briefing individuals
58
is but
1B
one
of
of the
the
factors that the pretrial chamber took into account to support
As
its
these
conclusions
are factors
on Mr.
that made
Duterte's
in briefing individuals
to interfere
it does
with
not
the
refer
against
to statements of close
in the
it does refer
in relation
it
to
does
the
refer
gravity
to
of
statements
the
of
alleged
close
crimes
associates,
and the possibility of
including
alleging
one
of
sentence
non-governmental
was
organizations
one of the
and a
factors
press article.
the pretrial chamber
The appeals
into
chamber
account
calls
in its
that there does
assessment
not
of risk
exist under
in the
Article
applicable
58
law of the
subparagraph
court
1
any
and 2 of the
impediment
statute.
to use
And it
of
looked
newspapers
at the
articles,
specific
or
allegations
other public
against Mr.
or open
Duterte
sources
for the
follows
purposes
that
of
the
assessing
defense
the requirement
has failed
under
to
Article
demonstrate
58
an
and 1
error.
of the statute. Nor
Regarding
is
the question
there any
of whether
requirement
the pretrial
that such
chamber
material
erred
in fact point 2
by failing
of the
to give
statute
appropriate
is
provisional
weight
in
to
nature.
relevant
I would
facts
like to inform the
to the
public
specifically that it
Mr.
will
Duterte's
periodically
health
review
condition
at least
and its
every
mitigating
120
effect
days
on the risk
or
factors
at any
set
time
out
in Article following a request by the detained person
by
or
the
the prosecutor.
to ensure
If satisfied, the
that the
appeals chamber
circumstances
recalls
so require
that there is no
the pretrial
provision
chamber
in the
may
court's legal
modify
text
its initial
that ruling on
specifically
detention provides for the
Article
interim or conditional
60.3
release
of the statute
of a detained
and Rule
person 118.2 of the rules. Nevertheless,
and
the appeals chamber has indicated that the medical condition
regarding
of
the
a
first
detained
ground of appeal
person and the
may
question
have
and
an
effect
effect
whether the
on the
pretrial
risks
chamber under
aired in
Article
Law
58
by
by relying
relying
on hypothetical and non-specific
may
risks
be a
defined
reason
for a
that
pretrial
continued
chamber
detention
is
to
warranted interim release. The appeals chamber
with
recalls
conditions.
that in determining whether the conditions chamber considers 60 such determination is necessarily a chamber must find that detention appears necessary to the defense's assertion. In this context, nowhere the appeals chamber observes suggests that a determination shall be made concerning the possibility information about Mr. Duterte's inevitability within the context that one of its events listed under Article 60.2 of the statute will occur. Rather, it noted that it is the responsibility of the relevant chamber and considered that the evidence before unable pursuant to the relevant finding on risks under Article 58(1)b of the statute. The defense, the appeals chamber shows that the pretrial chamber assessment of risk chambers under Article 58(1)b of the statute. For this reason, the pretrial chamber, having rejected the defense's arguments under this ground of appeal, indeed, the first ground of appeal, the pretrial chamber correctly referred to the standard that the assessment under Article 58(1)b of the statute concerns the possible ground of appeal, not the inevitability. I will now turn to the second ground of appeal. It then, under this ground, the material before challenges against the Pretorial Chamber's assessment of the proposed conditions of release and state guarantees. Accordingly, the defense has failed to demonstrate that the Pretorial Chamber misapprehended in failing to address the proposed conditions of release of risks and state under Article 58(1)(b) of the statute. The Appeals Chamber, with regard to the view that the Pretorial Chamber did not weighing of evidence in assessing risks on article in the proposed condition, subparagraph, but rather in the details as the Appeals Chamber notes that the Pretorial Chamber accepted to receive the 5 documents would implement, including necessary media articles, publications of the Pretorial Chamber did not consider release with conditions as required in its view, found indicated in the circumstances that Mr. Duterte's inclination to interfere with investigation could not be mitigated by the proposed in relation to the first document, a media article. Moreover, the Appeals Chamber finds that it was not unreasonable that the Pretorial Chamber was not obliged to rely by the defense this document for its observations from the concerned state. Whilst this document does not mention Mr. Duterte himself of release as being directly the risks it found in briefing individuals, it does not refer Article 58 to statements of closed statute. It does refer for these statements of closed associates finds that the defense has failed to identify an error by the Pretorial Chamber when addressing the proposed conditions of release, and the Appeals Chamber observes that Mr. Duterte's alleged involvement in briefing individuals of whether the Pretorial Chamber erred in law that the Pretorial Chamber took into account if the proposed state guarantees could mitigate Duterte's risk under Article 58(1)(b) of the statute. The Appeals Chamber finds that this does not appear from the impugned decision that the Pretorial Chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the Pretorial Chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the Pretorial Chamber when examining the implementation of conditions that it did consider them. Finally, the Appeals Chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the Pretorial Chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the Appeals Chamber is of the view that the defense failed to substantiate the Pretorial Chamber's conclusions were unreasonable. Regarding the defense's contention that the Pretorial Chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the Appeals Chamber considers that the Pretorial Chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed proffered conditions in a situation such as the one at hand. It did so against the backdrop of having found that all 3 risks under Article 58(1)(b) of the statute were established. As such, it was reasonable for the Pretorial Chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected. Third ground of appeal. Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering humanitarian grounds either as independent consideration or mitigating factor in assessing interim release, the appeals chamber considers that the pretrial chamber did not refuse to address the question of interim release on humanitarian grounds. Rather, it gave the reasons for which, in its view, the humanitarian grounds advanced by the defense were not sufficiently set out in the case at hand. Further, the appeals chamber recalls that the medical condition of a detained person may be a reason for a chamber to grant interim release with conditions, and that the chamber enjoys discretion when deciding on conditional release. The appeals chamber considers that it is not apparent from the pretrial chamber's assessment that it was unreasonable. The pretrial chamber found the existence of risks under Article 58(1)(b) of the statute, which were not mitigated by Mr. Duterte's purported condition, and also could not be mitigated by any condition imposed upon release. The pretrial chamber then proceeded to analyze whether humanitarian grounds, as argued by the defense, could justify release on conditions. The appeals chamber thus considers that the pretrial chamber assessed the relevant information before it in light of the arguments made by the defense and reached its conclusion on this basis. It follows that the defense has failed to demonstrate that the pretrial chamber's assessment was unreasonable. Accordingly, the appeals chamber finds that the defense has failed to show that the pretrial chamber erred in its assessment. For these reasons, the third ground of appeal is rejected. Finally, the appeals chamber notes that the pretrial chamber reached three grounds of appeal presented by the defense in the appeal brief. The appeals chambers unanimously confirms the impugned decision. This brings us to the end of the summary of the appeals chamber's judgment. The judgment will be notified to the parties and participants after the hearing. Translations of the summary will also be available in due course. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We will